was not long ago that fathers had virtually no rights at all. In the event of a custody battle, a father could expect to see little or nothing of his own children. Mothers were almost always granted full custody of children in legal proceedings, and even basic visitation was generally the mother's place to decide. Historically, unmarried fathers have had fewer rights with regard to their children than either unwed mothers or married parents. Over the past several decades, unmarried fathers have challenged the termination of their parental rights under the 14th Amendment in cases in which birth mothers relinquish their children for adoption. In a series of cases involving unmarried fathers, the U.S. Supreme Court affirmed the constitutional protection of such a father's parental rights when he had established a substantial relationship with his child. The court found that the existence of a biological link between a child and an unmarried father gives the father the opportunity to establish a substantial relationship, which it defined as the father's commitment to the responsibilities of parenthood as demonstrated by being involved or attempting to be involved in the child's upbringing. And the times are changing for fathers. While many fathers today already know that they do indeed have rights, most do not know enough about fathers' rights to ensure that they are not on the losing end of the stick. These days, there are options in custodial arrangements which did not exist only a few years ago. Fathers' rights have extended to the point that the court system is in agreement. The idea is for fathers to have as much right to their children as the mothers have to them. Fathers' rights no longer mean fathers settling for little or nothing when it comes to their own children. Today's interpretation of fathers' rights mean you can be part of your children's lives. The basic concept of fathers' rights is that parenthood and parenting should not be determined solely on the basis of gender. Even when a divorce takes place, it should not limit a father's presence or involvement in his children's lives. If you are a parent, you already know why this is important. No matter what age your child may be, you have been a part of his or her life thus far. A father's everyday presence and involvement has not only been important to the dad, but important to their children as well. Your child has come to love and depend on you. This should not change due to the dissolution of a relationship with a biological mother. As fathers' rights today are moving more on the father's side, dads can continue to meet their youngsters' needs as well as their own. In this Insider exclusive TV special, we go behind the headlines in Fathers' Rights, What You Need to Know, to investigate how Terri Miles, partner at Terri Miles Law, won a landmark Louisiana Supreme Court case on behalf of her client Alex in a case that concerned the opposition of a biological father to the private adoption of his newborn child. The Louisiana Supreme Court's concurring decision expressed concerns about the constitutionality of the Louisiana Children's Code, Article 1138, in that it denies equal protection to a father by demanding proof of fitness by an unwed father and not from the unwed mother as well. Terri will discuss some of the most frequently asked questions regarding fathers' rights, such as, when does an unmarried father require parental rights? Can the state terminate a parent's rights over their children? How is child support ordered and what exactly is it? What is child support and how is a child support determined? Does every state follow the same formula in calculating child support? What factors are used to calculate child support payments? Can the amount of the payment change over time? Can a child support order be changed or modified? How does the court decide who gets the children? What happens to custody when one parent needs to relocate? And what is paternity? Terri Miles has earned the highest respect from citizens and lawyers alike as one of the best family trial lawyers in New Orleans, in Louisiana, and in the nation. She understands that some of our laws have viewed fathers as second-class citizens with fewer rights than a mother of a child, frequently referred to as maternal preference. And because of that, she is driven to fight for equal rights for all people, especially ones who have difficult family law issues. Terri has built a substantial reputation by consistently winning cases other law firms have turned down. Her amazing courtroom skills and headline-grabbing success rate continue to provide her clients with the results they need and the results they deserve. This is the Insider Exclusive, live from New Orleans, Louisiana. It is my great pleasure to introduce Terri Miles to the show. Welcome to the show, Terri.
Thank you.
Tell our audience a little bit about your firm and what type of law you practice.
I practice family law. I'm a sole practitioner, but I do have one attorney, Ali Chalet, that works with me and does contract work for me, and he has his own practice as well. He does personal injury and other areas of law. I do strictly family law, which is custody, child support, community property, adoptions, things of that, name changes, things like that.
What is your favorite area of family law? The one that you have the most passion for?
Child custody.
And why is that?
Because I have children and I have grandchildren, and I think a parent's right to their child is probably the most primary right any individual can have. Mm-hmm. And I just really enjoy working with people in the area of their families more than the property areas.
Mm-hmm. Today we are discussing a custody case. Tell our audience a little bit about who your client Alex was and his son Micah.
My client is a Hispanic young man from south of Houston in Texas. He had a relationship with this girl out of wedlock, and she became pregnant. They lived together up until about the 8th month of her pregnancy, and she told him that she was leaving to connect with a former child another child she had from a former relationship, and would be back to have the baby. She didn't come back.
She abandoned him, basically.
She abandoned him at the end of her pregnancy, and he didn't know where to find her. He knew she was due to have the baby and started searching for her. And he went to an attorney in Texas who referred him to me because he had suspicions that she had transferred to Louisiana and had the baby already. And when he contacted me, he had brought a piece of paper he had found that was a provisional custody by mandate, giving someone else temporary custody of his child. And I looked at the document and I knew the name of the attorney who had notarized it, and the only thing that attorney does is adoptions.
Right.
So I knew immediately that his child had been placed for adoption without his consent.
Okay, and what did he immediately do?
He contacted me to ask me how to go about getting his child back or finding out where his child was, because he had not surrendered the child for adoption.
Now, had the child been surrendered or given to another party at that time, or the mother still had the child at the time?
The mother no longer had the child.
I see.
The adoption had already started.
Okay, and the child was with that?
The child was with the adoptive parent at that time.
And in this particular case, tell our audience the difficulty you had with this because of the ambiguity of the laws in the state of Louisiana regarding the rights of unmarried fathers.
Unmarried fathers are expected to know the law, but it's well hidden, and I would say very few would even know that they're required to file an acknowledgement of paternity in what's called the putative father registry, to prevent the child from being adopted without them receiving notice.
Right.
But very few people know that law even exists. So the first thing we did when he came to me was register in the putative father registry that he believed he was the father of a child born to this woman about this date in Louisiana. Therefore, he had to get notice of that pending adoption. We found out when I contacted the attorney that was on that document that he was representing an adopted individual in the state of Georgia who had custody of the child by that time.
So now we're dealing with 3 states, basically.
Correctly. The father and the mother. The child was conceived in Texas. The mother came to Louisiana, gave the child up, and the adoptive parent was from Georgia.
One of the other aspects of this case was the mother had acquired a new boyfriend.
Correct.
And that new boyfriend had signed on the dotted line saying that he actually was the biological father. He lied on a legal document, right?
Yes, he did, and that's how they were able to put the child up for adoption. She said he was the father. That probably happens more than we know, because when a couple comes to you to put a child up for adoption, there's no DNA testing.
Yeah.
The mother's still pregnant. We don't know. We take their word for they're the father, they're the mother.
And the child's birth certificate did not identify a father, did it?
The child's birth certificate had her boyfriend's name on it as the father.
Let's talk about some of the challenges that you faced in helping your client when you originally took this case, because the law was unclear, correct?
Correct.
What did you have to do? And another thing is, your client was not a well-heeled client. They didn't have like a lot of money or anything, did they?
No, he built scaffolds for a living.
Yeah.
He didn't finish high school. He was very talented in drawing. He was a young man, had minimal income.
Yeah.
And when I took the case initially, I thought that all we would have to do is contact the attorney that represented the adoptive couple, ask for DNA testing, and if it showed my client was the father, then they would return the baby.
Yeah.
That's how we started this. We
Right.
contacted him, asked for DNA testing. He did not believe that the child was my client's child. He didn't believe there had been any
You're
mistake.
talking about the new adoptive parents.
Yes.
Yeah. In other words, they were not cooperative.
They were not cooperative. They delayed the DNA
Yeah,
testing
let me
for a
ask you a
couple of
question.
months.
They probably spent money. They probably loved the child. This is their dream child. Why would you expect them to be cooperative?
I really expected them to be difficult because I can't imagine the pain in giving up a
Yeah.
child after waiting to adopt.
Right.
But if there is a problem in the adoption and you understand there is a parent out there that did not give consent, that's the right thing to do, and
Yeah.
the sooner the better.
And these folks were not that cooperative, right?
Not cooperative at all.
So how did you get the DNA sample?
Finally agreed to the DNA sample. It took a couple of months.
Yeah.
We got the DNA results back fairly quickly, and my client was in fact the father of the child.
Now you had a document that stated that the boyfriend, this other boyfriend, said that he was a biological father. How did you overcome that?
We had to file something with the court because the adoptive couple refused, or adoptive mother refused to accept that. She wanted to keep the child, so she filed to go forward with the adoption, and we had to oppose the adoption.
Really? Now tell us a little bit about what happened eventually. You won at the trial level, didn't you?
Yes.
But it was appealed to the Fifth Circuit, is that correct?
Fifth Circuit Court of Appeals overturned
And they reversed it.
Yes.
Okay, and then it went up to the Louisiana Supreme Court, right?
Yes.
And what did they do?
They granted writs, and they agreed with the trial court that the child should be returned to the father, that
Yeah.
he had met his burden of proof that he was the father and had in fact shown intentions that he was capable of parenting, that he had supported the mother during her pregnancy, and that he was fit to parent.
Okay, and they also made a very big point about the fact that the law was a little bit ambiguous, correct?
It is. It doesn't really protect the father's rights. A mother that doesn't want to turn her child over for adoption just simply withholds her consent.
Yeah.
And that's all there is to it. But the father coming forward has to prove that he has taken a substantial interest in the child,
Yes.
his parenting, that he is the legal father, and he's fit and proper to parent the child, which then goes into, is he educated? Does
Yeah.
he have the means to support the child? They covered everything that tried to paint him as a gang member,
Yeah.
as a felon, anything negative they could find all the way back, even to high school when he dropped out of high school,
Yeah.
to use to show that he was not fit to parent the child.
Now, the Supreme Court, I'm going to read this, they expressed concerns about the constitutionality of the Louisiana Children's Code, Article 1138, in that it denies equal protection to a father by demanding proof of fitness by an unwed father and not from the unwed mother as well.
Correct. The unwed mother doesn't have to show that she's fit. She doesn't have to prove that she can care for the child. If she withholds her consent, that's
Yeah.
all that's necessary. The father, on the other hand, has to go through all of these steps to
Yeah.
prove that not only that he is the father, but that he can parent and he has the means to support the child, and that he has taken
Yeah.
steps to do that during her pregnancy, which is a very difficult burden for some men to prove. And the mother doesn't have a burden.
As a result of this court's decision, the legislature changed the law, didn't they?
One of the main changes in the law was now there's a law on the books. If a mother gives false information about the paternity of the child, she can be convicted for that fraud, and she can be ordered to pay up to $10,000 in fines and serve up to 5 years in prison for
Right.
giving false information about the paternity.
So this was a huge victory for not only your client, but also for advancing fathers' rights, right?
For fathers, yes. And it has worked, I believe, in other adoptions that I've seen. if the mother knows that that is facing her, and that's one of the requirements for an adoption, there has to be an affidavit that she has been read that law and explained to her. And they often come up with the name of a father when they're saying fathers unknown. You read them that statute, they have a memory. They remember all of a sudden who dad is, and they're not willing to go to prison just to withhold his name.
That's good. Now, our audience has some questions. They sent them in to us, common questions about father's rights. When does an unmarried father acquire parental rights?
I think it should be at birth, but it appears, according to the law, it's when he takes the initiative to file an acknowledgement of paternity if it's an unwed father, and then takes the initiative in court to be granted joint custody with the mother.
Can the state terminate a parent's rights over their children?
Yes, there are provisions in the law to terminate a parent's rights for unfitness. That's the state's job to do. If there's a state investigation for cruelty, abandonment, abuse, or neglect, social services can terminate a parent's rights.
Every state has slightly different laws regarding parental rights, but none of them can contradict the equal protection under the U.S. Constitution, can they?
They shouldn't be able to, but the majority of them do. Some states give very little procedure for a father wanting to come forward and claim his child.
How is child support ordered, and what exactly is it?
Child support is for the care and support of the child, regardless of which parent has the child. I have fathers and mothers who are receiving child support from the other parent, married or a child born out of wedlock. Either way, child support can be ordered. Louisiana has a set of guidelines, it's calculations. Both parties' incomes are joined together, and then there's a calculation by the number of children, and there's a statutory amount for what the child support should be.
Does every state follow the same formula in calculating child support?
It's not identical, but from the other states that I've dealt with, the formulas are very similar.
Is a father who never married, the mother, still required to pay child support?
Yes, absolutely. He's still father.
And what happens to a father who refuses or doesn't pay child support?
Contempt rule would be filed with the court. He would have to come in and show why he didn't pay. Could be ordered pay court costs or attorney's fees, penalties. If he starts paying, then it comes out of his pay automatically. It's garnished out of his payroll.
How does the court determine who gets custody of children?
I would say that's different in every jurisdiction. There are statutes that say what the court is supposed to review in order to grant custody to the parents, the relationship between the parent and the child, the one that has the strongest attachment to the child, the one that does most of the parenting of the child. There's a number of factors that are considered. Nowadays, it's more common to do shared custody where each parent has the child approximately 50% of the time.
What happens to custody when parents relocate? That's a big decision.
I believe Louisiana has one of the strongest relocation articles in the country.
Really? What is it?
It's very difficult. The parent who wants to relocate is required to notify the other parent in writing, preferably 60 days prior to the intent to relocate, telling the other parent where they're relocating to, why they're relocating, how it's going to benefit the child, and what can be done as far as contact with the non-relocating parent.
Right. In your practice, family law, you do quite a bit of collaborative law, don't you?
Correct.
What is that exactly? And how does that work? And how is it better than, for example, going to court and battling it out in the court?
Collaborative law is relatively new. It's a team approach. In collaborative law, there's an attorney to represent both parties. Each party has a coach, who's usually a social worker. They have an accountant that's part of the team to calculate support or to calculate property divisions. And the team comes together to kind of mediate the decisions. Everything is open and on the table. There's no problems with discovering what the other one has. There's no hidden agenda. Everything is laid out and open to everybody present. The attorneys can talk to either party, not just their own party. The coaches serve a purpose to help keep the parents in the process of negotiating and mediating, to balance some of the emotions and animosity.
Do you also find that it's generally less expensive if you go the collaborative law route than rather than go through divorce court if you're going to dissolve a marriage.
It usually is less expensive, even though you're paying for everyone on the team as
Yeah.
opposed to just two attorneys.
Yeah.
The results are usually easier to come to and quicker than litigation.
Is there anything that you want to say to the American people today, especially the people in Louisiana, if they're having difficult family law issues? What do you suggest they do?
I suggest they try to talk them out, if at all possible. If they can,
Between
they
themselves.
can amicably communicate.
Yeah.
If not, mediation is a good process
Yeah.
to keep it out of litigation. And if litigation is the only possibility, then look for attorneys that are willing to work together and openly and try to resolve things and keep it out of court as much as possible. I don't believe family law really belongs in the courtroom.
Because it's very emotional.
It's very emotional, and it usually by the time it gets to litigation, it's a very ugly process between the parties. If you can avoid that at all by mediating or the attorneys working together, and that's pretty common among a lot of the attorneys around here. We
Yeah.
get a case, we work together to resolve it and try to keep it out of the courtroom.
Well, congratulations on this big case.
Thank you.
Fathers' rights are definitely advanced tremendously, and I want to thank you very much for spending time with us on our show.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.